Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Sanfiru Tumarkin and the Western Canada Employment Practice Leader. Thanks for joining me today. We are here today to discuss your employment rights. Any questions that you might have related to your employment. For the next half hour, I'm going to try to get through as many of them as possible. So, any question you have, simply put them in the chat, and we'll get through as many of them as we can. We had an interesting situation this week. Starlink, the wireless internet company, went down for quite a few hours, and the question arose. If you're an employee and you are no longer able to connect to the internet, what is your obligation to your employer? Especially, for instance, if you're in a work from home environment, do you still have to continue to work if you cannot connect to the internet? So it's an interesting question. Of course, as you can imagine, there's no law that addresses this fact specifically, but generally you are required to work for any time that you're being paid. So unless you've received an instructions from your employer to not work, you are required to at least be available for work. Really, what your employer is purchasing from you is your time. So definitely what you cannot do is just go and play hooky, go do some shopping, do stuff where you wouldn't be available to look for work, to work for your employer if the internet came back on, or if there are tasks that you could do without the internet. So generally, always keep in mind that you're being paid, in the kind of classical view of work, you're being paid for your time. And so that time, essentially, if you're getting paid for it, belongs to your employer. You have to keep yourself available for your employer to use you as they need, within the confines of your job description. Keep that in mind if these kinds of situations arise. Always best to check with your employer what they would like you to do when you have these kinds of situations. We have a question coming in from YouTube from Beth. Beth is asking, my coworkers and I arrived at work on time according to our schedules, but our manager got upset and said she'd contact HR if we don't start coming in 10 minutes early for her daily meeting, even though we're not paid for that extra time. We usually stay late and get paid for it, but we've expected to show up early without pay. Is it legal for her to demand that? Should I contact HR? So, Beth, you're absolutely in the right, and your manager is in the wrong. If you are not being paid, you are not required to be on the work site. All right, there's no real kind of payment outside or obligation to be on the work site outside of working hours to perform unpaid work or anything like that. So that is not an expectation your employer should have. And if they insist on having that expectation, then yes, definitely talk to HR. And if HR is not being helpful, then you can talk to the Ministry of Labor, who will require your employer to pay you for that time. All right. So, and if you're working an 8-hour day and you're being asked to come in early and work longer, especially if you're here in Alberta, anything over 8 hours is overtime pay. They're going to have to pay you time and a half for requiring you to come in early. Now, if you're in a situation where you are paid a salary rather than by the hour, and especially if if your schedule is less than 44 hours a week or 8 hours a day, then your employer can require you to come in and on a salary work up to 8 hours a day or 44 hours in a week, as part of what's covered by your salary, even though they might have internal expectations that your work week will be 37 and a half hours. But if you're being paid by the hour, you need to be paid for every minute that you're at the workplace. Absolutely performing work. Now, of course, if you're on lunch, unpaid break, things like that, you might still be at the workplace. You're not entitled to be paid, but you're entitled to leave the workplace if you need to go do your lunch or whatever you want to do. All right. So definitely, your employer should not just be moving these meetings, beginning of day meetings, to the lunch break or anything like that. At the lunch break, you are not being paid. You can leave the workplace. You don't have to attend any meetings during that time. We have another question coming in from Cora J. Cora J asks, I work for a small business owner who is verbally abusive and very difficult to work with. Is there a way that I can leave this job and receive EI? It's affecting my mental health and I just can't continue. All right. So there's a concept called constructive dismissal, which is essentially what you're proposing here, Cora, where you're leaving not because you want to leave, but because you're being forced to leave by your employer's behavior, aggressive behavior. And if you can prove that your employer is being aggressive and overly aggressive and inappropriately aggressive to you, or you use the word abusive, so let's use that word, abusive, and being very difficult to lead, to work with, then essentially you don't have to put up with it. So there's a few remedies that you have. One, you can make a harassment complaint. You've told me it's a small business, so there might not be an HR department that you can go to. But you can make a harassment complaint to the owner, who himself is the problem, or make a harassment complaint to the Ministry of Labor. Two, you can treat the harassing behavior as a resignation, as a termination, and leave and seek your severance entitlements. And three, you can also apply for EI. So when you apply for EI, you'll be asked, why you left, and then you'll explain, well, I resigned. And so when you do that, EI will begin an investigation as to why you're claiming EI if you resigned, in which case you'll have to explain that you resigned for a cause. You had reasons to resign. You were constructively dismissed, in other words. And if EI agrees with you that you had no need to stay in that place and continue to be abused, then EI will allow you to receive EI benefits, and you'll be enrolled into EI benefits while you look for new work. But you can expect that after you submit your application, EI will do an investigation. Will ask for your side of it, ask for the employer's side of it, and if they conclude that yes, you were being verbally harassed or abused at the workplace, they will allow you to obtain EI and continue that way. So you want to start thinking about, well, how am I going to prove that my boss is verbally abusive? Could be one of those, either a colleague is willing to testify or willing to corroborate what you've heard. It could be that you can record one of these interactions on your phone, or several of these interactions on your phone, to substantiate what's happening to you. It might be that it's not just verbal, it's in writing. The emails are also abusive and stuff like that, so you might want to kind of record that. They might be leaving messages or text messages. You want to have some evidence to back it up rather than just your word against theirs, essentially, is what I'm trying to say. So think about that. But then once you have that, once you've got your ducks in a row, and once you've decided I can't continue to work in these conditions, you can quit. You can tell your boss, I am quitting because you constructively dismissed me with your abusive behavior, and I'm seeking my full severance, as well as I will be applying for EI. And if you're looking for an idea of what your severance entitlements might be in a situation like that, you can visit employmentlawyer.ca and our pocket employment employment calculator. The Pocket Employment Lawyer at pocketemploymentlawyer.ca. We got our severance pay calculator there. If you answer 4 easy questions, we'll be able to tell you how much severance you're likely owed. All right, so visit that. You get an idea of what your severance entitlements might be. And from there, if you want to pursue those, we're happy to help. Just reach out to us at employmentlawyer.ca. We're happy to help you get your severance entitlements. We have another question coming in on YouTube from 1982 Bobby, who states, currently on maternity leave, I've just received notice from my employer that my job will be terminated. I have 8 years of service, effective after my leave ends. However, they claim they have already given me 10 weeks notice during my leave from now until the end of my leave, and that it counts under employment law. Severance-wise, they're offering me a small lump sum in cash after my leave ends, not now. They are claiming financial hardship, but no one else got terminated. Any insights as to my next steps? Okay. Well, a few things, 1982 Bobby. So firstly, this notice that they're giving you while you're on leave doesn't count, okay? So they have to pay you if they want to call it notice, they have to actually pay you your salary. So it doesn't seem that they're doing that. So it doesn't count as working notice of your termination. So in fact, you are owed your full severance as pay in lieu of severance of notice. All right. So they have to pay you your full severance right now. You may be wondering, what is my full severance? What am I actually owed after my 8 years of service? So as you might have just heard, Bobby, we have the severance pay calculator. The length of time you've spent at your employer is definitely an important factor in deciding how much severance you're owed. There are 3 other questions that we ask you, very easy questions to answer, and then we'll give you an estimate of what you might be owed. All right. So that's at severancepaycalculator.com. Severancepaycalculator.com. You'll get an idea of how much severance you're owed, and from there you can decide whether you want to pursue that severance, how it compares to what your employer has offered you. You're telling me a very small lump sum, so probably you're entitled to more than that. All right. Secondly, you say they claim they have financial hardship. So keep in mind that doesn't affect how much severance you're owed. All right. Whether your employer is struggling financially or doing very well doesn't affect how much severance you're actually owed. Okay. And if they are saying that to try to convince you that that's the reason why they terminated you, and you don't actually believe that, if you think they've terminated you for another reason, amongst other things because you took a maternity leave, or because they hired someone to replace you and they like that person better, or whatever it is, that's human rights discrimination. That's gender discrimination, and that entitles you to an additional sums of money, including for human rights violations and all of that. So really, what I think your best path forward right now, Bobby, is to get in touch with us. We're happy to take a look at this for you, get the full picture, and explain to you what your legal rights are and rights and remedies are right now, because you're in a very vulnerable position right now. You are, caring for a small child, trying to get back into the workforce while you're figuring out childcare and all of that. You need your employer's support now more than ever, rather than what they've done to you, which is basically hung you out to dry. And while they're at it, try to trick you out of your severance. So what your employer is doing is incorrect and it's unfair. And so we want to help you. Reach out to us. We're at employmentlawyer.ca. We're here to help. We have another question coming in from PooTube. PooTube asks, federally regulated employment unjust dismissal case. Awaiting on Canada Labour Board response almost a year now. Should it be there? Is there any other process you recommend, please? Okay. So, yes, if you're federally regulated, you have the option of bringing a federal unjust dismissal complaint. If you bring an unjust dismissal complaint, Putu, you are likely not going to be dealing with the Canadian Industrial Relations Board right away. You're going to be dealing with the internal branch of the federal Ministry of Labor. All right, the Employment Standard Branch. All right, so they're going to get back in touch with you. Right now, the delays are outrageous. Frankly, it should be unacceptable that it takes over a year just for them to look at your form. But that's what we're dealing with right now. All right. So if that's an issue for you, you should contact your MP. Let them know that you've been waiting over a year for someone to look at the form, and you've been unemployed and unjustly dismissed potentially all this time. Really, justice needs to move a little faster than this, in my view. You also, if you've been unjustly dismissed, you've probably also been terminated from your job. You can bring a wrongful dismissal action potentially if you haven't been provided with enough severance. All right. So again, if you're looking to see, well, how much severance am I owed? That's severancepaycalculator.com. Severancepaycalculator.com. You have 4 easy questions that we can give you an estimate of how much severance you're owed. And you do that through the court system potentially with the help of a lawyer, and we're happy to help. So if you've punched in the information, you've gotten an estimate, and you're thinking, yes, this is an amount I'm willing to pursue, then reach out to us. We're at employmentlawyer.ca, and we can talk to you about how you go through about going after your entire severance, your total severance, through a lawyer. All right, and we're happy to help with that as well. We have another email coming in from James. James is asking, my employer keeps messing up my paycheck, just like 2 hours here and there, but no one notices it unless I say something. I've just noticed about a month and a half ago, but now that how long there's been discrepancies. What do I do? So if they are refusing to correct your pay stub or pay you what you're actually owed based on what the hours that you've actually worked, then you can bring a complaint to the Ministry of Labor, to the Employment Standards Branch of the Ministry of Labor. And if they are keeping inadequate records, you could probably bring a complaint regarding that as well. So first thing you can do is tell them, listen, if this keeps on happening, I'm going to have to escalate this to the Ministry of Labor. They're going to open an investigation as to why you guys are unable to track my hours. How hard is it? What is the complication? Why are hours disappearing here? And that opens them up to being fined and being monitored. And this investigation can spread from just your paycheck to all the paychecks of all the employees at the company. So it could become quite problematic for them if they don't get their ducks in a row and learn how to properly conduct payroll, right? So if this happens again, like I said, reach out to the Employment Standards Branch of the Ministry of Labor in the province where you're located. And that could be, I've dealt with the ones in Ontario, BC, and Alberta. And the initial complaint process is online or by telephone. In Alberta, at least, I think it is in BC as well, and in Ontario, it's a form you fill out. But definitely get on it, because in Alberta, they have a very short limitation period, which means that you can't complain about stuff that happened more than 6 months ago. So you have 6 months to catch it, all right, and to make your complaint so that they keep on going forward. So you got to keep an eye on that, because the time you have to make your complaint is quite short, all right, so keep an eye on that. We have another question coming in from Reddit from Tats. Tats is asking, 2 days ago, I was rushed to the hospital for emergency appendicitis surgery and texted my manager from the hospital to explain I wouldn't be at work. Today, while I'm still recovering, HR left a voicemail threatening termination for job abandonment because I didn't follow their specific calling procedure, calling in a certain number instead of texting. I'm in Ontario and shocked by how this is being handled. Can they legally fire me for this? And what are my rights if they try? So, no, they're not legal. So I'm not exactly sure what is happening here, Tats. Does HR know that you've told your manager you were off? If your manager told them that you're in the hospital and they're saying that you abandoned your job because you didn't text the right number, that's a little bit outrageous. But it seems to me that if they have the brain in their head, the only reason they're doing this is because the manager didn't tell them. So if you're able to, or you're able to get someone, a family member or a friend, to reach out to HR and explain the situation, that's the easiest probably way of resolving this. You definitely want to kind of, if you're capable of it, and you do seem capable of it, you want to just inform them of what's happening. I'm not really all that concerned whether you use the right number or the wrong number, so long as they know, right? I mean, the email, carrier pigeon, it doesn't matter, but they need to know why you're not coming into work. But if you're saying that the manager told HR and they're going to consider this job abandonment because you didn't use the right number as you were being rushed to the hospital in an emergency situation, that is not job abandonment. I think they're in a bit of trouble here if they try to say that, all right? So listen, procedures are nice and great to follow, but in an emergency, like, people need to, make allowances for the fact that you might not have the wherewithal to have on hand the right number to text for, an absence, right? So I think I share your outrage at what is happening here, but I suspect there's a bit more to it than you might realize. If, like I said, if HR might not be aware of why you're not showing up to work. You're just showing up as absent. It might be that the manager has included them in. So if you're convalescing in Brent, you're able to text the manager. Can you just ask them? Can you inform HR of what's happening? Because they've reached out to me and weren't able to reach me. I think it's a misunderstanding. It just seems so outrageous that it would be anything else, Tats. But do follow up at least with the manager. If you're able to call back HR, do that. And if you're not able, try to get either the manager or someone else, family member, a friend, another coworker, just to make sure that they know where you're at, right? I just don't think they would do this if they knew that you were convalescing in the hospital after emergency surgery. It just seems so surprising, but I've kind of seen it all as well. So if they do insist that no, you've abandoned your job because we knew you were in the hospital, but you hadn't texted the right number, if that does happen, Tats, reach out to us because that's outrageous and that's not the law. All right, and we're at employmentlawyer.ca. All right, I hope you get better soon. That should be your main focus here, trying to convalesce and get better, rather than running through, jumping through the HR hoops that they're putting up for you here. All right, we have another question coming in again from Reddit from Opposite. I worked for a company that laid me off during a corporate restructure. I was forced to sign an NDA if I wanted my severance pay, and I was under the impression that as needed, if needed, a reference, the company would provide one. I found out today that the company hasn't held up their end of the bargain, and during the last interview with a local university, the old company provided a bad reference check. What are my options and where do I stand? This is an American company operating within Canada. So there's a few things to do here. First is buyer beware. Okay, the law does not require companies to provide a positive letter of reference. Generally, when a new employer is asking you for references, you should put only references that you think are going to give you a good reference. Okay, and you've figure that out by asking your referees whether they would agree to provide you with a reference. Okay. That said, so that's just practical advice. It can be that for whatever reason, either you thought they would give a good reference, or the new employer contacted the old employer without asking you first. Could be that someone's given a bad reference. Now, like I said, a bad reference in and of itself is not illegal. An untruthful reference is a problem. Okay, references are a form of speech, and any speech is subject to defamation laws. All right, and so if they are spreading lies about you that are defamatory, it could be that you have a recourse against your former employer in defamation law. Okay, so you hear that and you ask yourself, well, okay, well, sure, what does that actually mean? Well, defamation law often starts with a cease and desist letter. Okay, so it may be that you need to hire a lawyer, hire one of us to send a cease and desist letter, and if the employer continues to provide bad references, then you may have to escalate the issue. But oftentimes, a cease and desist letter is more than enough to get that bad behavior to stop. Okay. The other thing that we often find in defamation issues is proving that the former employer gave a bad reference. So I'm a bit curious of how you found out that your former employer is giving bad references and how you found out precisely what it is that they said. Okay. A lot of people who suspect things, but proving something and suspecting something are two different things. All right. So unless you have a clear path at proving what your former employer said, and you also have some evidentiary problems there that you need to consider. Okay, so keep that in mind. But if someone has told you, yeah, I called your former employer and they told me X, Y, and Z, and you know that's a lie, and you know that person will be willing to testify that they were told that, and that's potentially defamation, right? So that's when you get in touch with us, and we can walk you through how you deal with that going forward. And if you're looking for some help with that, you have our website on the page on the screen there. It's employmentlawyer.ca. All right, and we have time for one last question coming in from YouTube from Steve. Steve is asking, I got injured at work just 1 week before completing my probation period. After I informed my manager about the injury, they canceled my upcoming shifts. 4 days later, I was told they were letting me go because I wasn't good at my job. Is this legal under WorkSafe BC? It feels like I was let go because of the injury. Okay, so a few things to unpack here. Firstly, if you're injured at work, your main recourse is, as you've stated here, to make a claim under WorkSafe BC so that you can continue to receive compensation if you're unable to work. I'm not sure if this injury that you suffered, Steve, prevents you from working. If it does, then WorkSafe BC is how you continue to get paid during your convalescence. Secondly, yes, it is. You can make a claim under WorkSafe BC that you've been reprised against for having made a claim. So if you were terminated for having made a claim or for having been injured, you have claims under WorkSafe BC, under human rights legislation, for having been terminated due to an injury or potentially a disability in this case. There are claims that you can pursue there, as well as potentially severance claims, but it seems you were under your probation period. So these claims can include lost wages from the day you were terminated until the day that you can potentially even be reinstated into your job. So it can be quite a substantial sum of money if that's really the reason why you were let go. So if you're telling me, listen, I really hadn't heard anything about why they were letting me go, and then all of a sudden, a week after I'm injured, they let me go. So I would say, basically, it becomes the employer's burden of proving that you were let go for reasons other than the injury. All right. So definitely something worth exploring. So if you are looking to pursue a claim either under reprisal or human rights legislation or even just severance, reach out to us. We're at employmentlawyer.ca. You have our website on the screen there. And you might think, well, I worked less than 3 months. I might not be entitled to a lot of severance. Well, actually, if you're reinstated to your position with back pay, that can take several months, even sometimes a couple of years. So that could be, even though you haven't worked there very long, you might have a very substantial claim for lost wages, even though you haven't been there very long. So definitely worth pursuing. If you go to our severance pay calculator, it might not show you a large entitlement, but we wouldn't necessarily be going after severance in that case. We'd be going after your lost wages and reinstatement into your position if you were terminated for discriminatory or retaliatory reasons. All right. So feel free to reach out to us, Steve. We're at employmentlawyer.ca. All right, that's the time we had today. I really appreciate all of you putting in your questions. We had some great questions once again today. They were really interesting questions. I hope some of these answers were helpful to you and give you a better idea of what your employment rights are in BC, Alberta, and Ontario, which is where we can operate and where we can help you. If you're struggling with any workplace issue, give us a call or reach out to us at employmentlawyer.ca. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada Employment Practice Leader. If for whatever reason we didn't get to your question today, we have another show tomorrow with my colleague Karen Taraposky. Will be on live at 1 p.m. Mountain Time to answer any questions you might have. So thanks for tuning in once again, and we'll see you soon. Bye now.